Item number 5. Basically, this is I asked to have this put on the agenda to give the commission a little bit of color. Executive Director Bennett and I, at the request of Conor McGregor, had a very good meeting and discussed a lot of things. And at the end of that meeting, for a number of different reasons, not only what's named in his request, but also based on our prior adjudication of this issue, the confusion around the SPA, the administering of the SPA, the value of the SPA, it's always been one that's been gray. So it is my opinion that I think that we should rehear this case, and that was why I asked for it to be put on the agenda. So I would basically at this point look for a motion, if the commission is in agreement with me, to rehear this case. So I would look for a motion to grant the rehearing.
Mr. Chairman, I agree with your comments and would make a motion to rehear this item.
I will second that motion, Mr. Chairman.
Wonderful. Any other comments on that? Okay, great. Then I would ask for a vote on the motion and the second. All in favor?
Aye.
Okay. Motion passes unanimously. Okay, good. I appreciate your support of my recommendation. Second, I believe I'm going to ask Executive Director Bennett if he would step down with Attorney General Bateman, and we can go through. From what I understand, they have, and it's in our packet, but they have, in anticipation of this, have worked with the other party and have a recommendation for us. And different than we've done in past potential settlement agreements, I would like him to speak to that, if that suits the commission. I know you all hear enough from Executive Director Bennett, as do I, but today I just have to let him talk. Go ahead.
Chairman,
Thank you.
good morning, Chairman and Commissioners. Before we get started, as always, ladies first, and seeing how she's the brains of the outfit, I'll let Deputy Attorney General Bateman start a short presentation, because most of you are very familiar with this particular incident.
Good morning. Good morning, Chairman Reinell, members of the Commission, Deputy Attorney General Caroline Bateman on behalf of Executive Director Bennett. We do have a proposed settlement agreement that is before the Commissioners today. And just to give a little bit of background on this case, back in late August when this incident first occurred, Director Bennett and I believe that afternoon got together. We reviewed the statements that we had received regarding the incident. We reviewed the videos of the incident and first considered, are we going to move forward with the complaint? And that was an obvious, given that the conduct that occurred during this press conference was not appropriate. It did affect the reputation of unarmed combat, and based on that, the decision to file a disciplinary complaint was, as I said, a given. We then moved into what we believed was an appropriate disciplinary action against the respondent. And the considerations we made first were that in the majority of cases before the Commission, which are the anti-doping violations, we rely on a percentage of the purses. That's based on the WADA code, it's based on precedent of this commission, that we go with a percentage of the purse as long as the contest went forward. We differentiated this case because there was no impact on the actual contest. So anti-doping violations, win or lose, there is an advantage for the contestant or contestants who took the prohibited substances. And so there is a direct link to the contest, and that's why we go look at the percentage of the purse that we think is appropriate. In this case, that model doesn't really work. One, because the conduct, although it did affect unarmed combat, didn't affect the contest itself. No one had an advantage in the contest, and so we decided not to go based on purse percentage. Second is that although there was that impact, to rely on purse percentages doesn't make sense in contexts such as this, because there's such a disparity oftentimes in the contestants' purses. So So even if two contestants have very similar conduct, which I believe was the case here, although one was a bit more egregious than the other, based on the purses and the differences in the purses, there would be a drastically different fine percentage, or I'm sorry, a fine amount based on the purse percentage. So for those reasons, we determined what would be an appropriate sanction, both as in terms of a fine and community service, to discourage such behavior as this in the future, to appropriately discipline the respondent, and send the message that this kind of behavior is not going to be tolerated by the Nevada State Athletic Commission. Based on all those considerations, the director and I came up with the suggestion of a $25,000 fine as well as a community service requirement of 25 hours. That has been the director's recommendation from day one. It was the recommendation that he gave to this commission during the respondent's first disciplinary hearing, and we continue to believe that that is an appropriate disciplinary action against the respondent to this day. Based on that, based on our conversations with the respondent and his counsel, we continue to believe that is an appropriate response, especially given the fact that the respondent did take full responsibility for his actions during the press conference. So based on that, we encourage you to approve the proposed adjudication agreement that's before you today. And unless you have any questions for me, I'll turn it over to the director at this time.
I have a question of you,
Ms. Bateman. At the original hearing, we had elaborate discussions with respect to the community service. Could you elaborate for us now what is proposed for the community service, or is that more properly placed with counsel for Mr. McGregor? Or what have your discussions been on that subject?
And Chairman Moran, I'll throw you to Commissioner Avancino. Commissioner Avancino, as you know, I was not present at that hearing. I was on leave. However, I did review all the minutes of the proceedings. And regarding the community service, the directors and I believe that the 25 hours that was recommended is appropriate for the conduct that is at question in this case.
No question about that. I'm simply asking what is the nature of the community service that will be done?
Maybe you can elaborate. I think where the commissioner is going is there was a lot of, it had to be here, it was a public service announcement, it was going to be recorded, there was a value to it, it had to be documented from the time he left his house in Dublin to the time he got here. It was basically a big mess that nobody could really understand, and frankly, I and I think the executive director and I felt uncomfortable administering it. So at this point, you're recommending in this settlement agreement 25 hours. Elaborate who, what, when, where, why, and how. That's what we're, I think,
Trying to understand. We had discussions about anti-bullying last time or anti-drug activities. Not suggesting that he's involved in that in any manner, but to try to prevent others from engaging in that type of activity.
Maybe you can share that for us.
Absolutely, Commissioner Avancino. Based on our discussions with Respondents Council and the manner in which the community service requirement is drafted in the proposed adjudication agreement, it would be any community service that is approved by the executive director. That can be at a gym, at a nonprofit, something that is previously approved by the executive director and is well documented. Let's say from a gym, the gym owner would provide a letter documenting when and where and how the respondent completed that community service. If the director had any questions for the respondent, he would have to justify those hours, but we are giving the discretion based on the proposed agreement to the executive director to approve the hours.
Executive Director, if I may ask, what is the timeline expectation to fulfill the community hours?
To fulfill the 25 hours of community service, whether it's done in Dublin and various gyms with children, and the work that he puts forth during that period of time, we would anticipate, we would recommend a 6-month period. And that, of course, could be done whether he moves here in Las Vegas and goes to a school and speaks to some kids of any type of nature that we can that we agree is conducive to the children and to the community.
So elaborate on that a bit. What do you expect to approve for Mr. McGregor with reference to the community service? Showing up at a gym and having...
That's exactly what we discussed, Commissioner Avancino, that he could go to a litany of gyms of his decision, his choice, and speak to the kids about anti-bullying, maybe show them some defense techniques, some different rolling techniques, if you will, jiu-jitsu moves, kickboxing, you know, everything that incorporates an MMA fighter. Not only share those self-defense techniques with the kids, but at the same time teach them the importance of anti-bullying and having the courage of their convictions and doing the right thing in life.
All right. Thank you very much.
Do you have any additional comments, Executive Director Bennett?
Yes, I do. I want to echo what Deputy Attorney General Bateman basically said and add a couple of things to that. That initially, and during the last hearing on October 10th, we did recommend a $25,000 fine, as you well know, 25 hours of community service, and of course for Mr. McGregor to incur the expenses for the Deputy Attorney General. And this was based on the fact that his actions weren't in keeping with the standards of a world-class athlete representing the UFC and the Nevada Athletic Commission in the eyes of the world. However, in the prior hearing, I believe the Commission was placed in a very difficult position, as Deputy Attorney General Bateman has stated, because there really isn't any precedent for this inappropriate incident that took place. There was some reference made to the Jones-Cormier incident, but I believe that that incident is not on point and does not present a fair comparison. I think in fairness to Mr. McGregor, I should also note, that he took full responsibility for his inappropriate behavior when he was on the telephone last time. The line was a little broken, but he apologized profusely, not only to the commission, to the fans, to everybody that had observed that activity. And, just said, hey, look, I made a mistake, I apologize, I'm asking for your forgiveness, and I would respectfully remind you that there was no settlement agreement in place. We didn't have any conversations with Mr. McGregor or his attorney Goldstein, as to, well, this could happen, he may get fined, he may get suspended. No, he just came forward and said, hey, look, I was out of line, I really apologize, I wish I hadn't done it. And he, in essence, he placed the outcome in the hands of the commission, which I thought was very honorable of him. And in the commission's wisdom, it granted Mr. McGregor a motion for reconsideration. Now, I want to stress my last point, in anticipation of this possibility that you were going to grant the motion for reconsideration, Deputy Attorney General Bateman, myself, in conjunction with Mr. McGregor and his counsel, we put a settlement agreement together for the commission's consideration. And that, of course, was the same, the $25,000 fine, 25 hours of community service, and to incur the cost of the Deputy Attorney General. I think in essence, this really covers what took place, and one of the key factors, I think, is that there really was no precedence, and this was a bit of an anomaly. And that being said, because it was a championship fight, and some reference was made to Cormier-Jones incident, as I previously said, that was not on point, and it wasn't a fair comparison, because this was a championship fight between Diaz and McGregor, and of course, what they were going to be making was significantly more than what Jones and Cormier did. Thus, the fines were higher. And in my opinion, with all due respect, I just didn't think that was fair. And I think that's why one of the main reasons the chairman decided for us to have a meeting and to make this motion for reconsideration. With that being said, I thank you, and I would be more than happy to answer any questions from the chairman of the commissioners.
Any questions for our executive director? Any of the commissioners? No? Pretty self-explanatory. Okay, so if I look at the proposed adjudication agreement and order that you have in front of us, I would like to ask Attorney Jennifer Goldstein if you can comment or provide any comment on, obviously, your signatures on the document. So I'm assuming that you and Mr. McGregor, your side, agree with what's been presented and proposed by our Attorney General, our Executive Director.
Thank you, Chairman. Yes, through you to the Commission, thank you for having us here again today, for granting me rehear. I won't be so pedantic as to reiterate what Attorney General Bateman and Executive Director Bennett have said, other than to say that we appreciate your understanding that this does warrant a hearing. What I heard Executive Director Bennett say was that he believed that the Jones-Cormier matter was different because the money at stake was very much different in the two different events. And I don't purport to know what either Jones or Cormier was getting. And so I don't know that it's even a matter of money, but what I will say is that substantively the acts were different. And as I think is what's before you today is the testimony that you had previously for those commissioners who were here of Conor McGregor, who is on the phone today, who, as Executive Director Bennett said, was heartfelt in apologizing and saying, although not unprovoked, he understands that this didn't reflect well upon the sport. We'd like to ask that you consider the proposed adjudication. We believe it to be fair. We believe it to be all-inclusive. Commissioner Avancino, to your question, it's quantitative. It's a 25-hour mandate. It's not qualitative. It doesn't say what he should do with that. But those who know Conor know that he will do something incredible. So we ask that you consider it and approve it. And if you have any questions, I'm happy to answer.
Any questions at this time?
I just want to thank you for clarifying that Mr. McGregor is on the phone telephonically. That was certainly one of the questions that I wanted to have the answer to, or just represented by you. Thank you.
Mr. Chairman, I don't have any questions. I just have a comment. And I think it goes back to, again, the $25,000 is a significant amount of money to some individuals. However, the real value in this situation is the number of hours of community service. For someone of Mr. Conor's stature or commitment, it will require definite time-consuming effort on his part, and I appreciate the effort by you and the executive director to reconsider this and come to a decision that's favorable to both parties. So thank you.
Great, thank you for your comments. Commissioner Carpenter.
Yes, sir. I just wanted to say thank you to Chairman Marnell and Executive Director Bob Bennett for rehearing this and being kinder, more judicious, and taking a less heavy-handed approach to this. And I'm thankful for that, being a new commissioner on the phone.
Great, thank you. Commissioner Avancino, do you have?
Yes, I think this is a very fair and appropriate resolution for an unfortunate incident, and I think Conor McGregor will continue to represent the sport in the magnificent way he has in the past.
Commissioner Alonso, you good? Come with a comment. Okay, well then I will, without any further delay, and I don't believe there's any reason to have Mr. McGregor sworn in or have any comments. We'll take Attorney Goldstein at her word, and it's good. So I would be looking for a motion. He probably just dropped off the phone right there.
He's still there.
I will be looking for a motion on the approval of new business item number 6, which is the proposed adjudication agreement and order between the state of Nevada and Conor McGregor.
Motion to approve.
I have a motion to approve. Do I have a second?
Second.
Great. All in favor?
Aye.
Aye. Great. Motion passes unanimously. Thank you.